Today's presenters are Kevin Adler, Program Attorney for the National Council of Juvenile and Family Court Judges, and Krista Delgado, Policy Manager at the Texas Council on Family Violence.
Hi, everybody. Thank you, Amber. So this is a presentation of the legislative update. This is a project of the National Council and the Resource Center on Domestic Violence, Child Protection, and Custody. Again, my name is Kevin, I'm a program attorney, although I'm only admitted in New York, though we're based in Nevada here. So shout out to everybody who's from New York, I see at least one. Let's get into this. So this is our disclaimer. I haven't read it, but it says basically that these comments are the sole responsibility of the authors, which are basically me and Krista, and these do not represent the official view of Health and Human Services or the National Council. So what do? Every week, the Resource Center, which is a project within the Council, reviews DV-related bills passed by the legislatures of every jurisdiction in the United States. This is the 50 states, D.C., and also the territories. So we get a decent amount of bills from Puerto Rico and Guam and Virgin Islands and all that. The bills are summarized, and the summaries are released a few times per year in newsletter format. Now you'll see in the files section of the webinar, you can download some of our most recent legislative news updates. Those are unfortunately from 2016. So for our regular listeners or readers, however you consume this kind of content, there aren't a lot of recent summaries. They haven't really been released a few times per year, and I apologize for that. That is something we're working on, and for sure, starting at least like this month and going forward, we will be releasing these regularly. So we hope these are a useful resource for people. This is the first time doing a webinar out of this project, but I'm excited to hope you all enjoy it. Later this year, we're hoping to put out a website. So we're hoping to be able to show like a searchable database of like bills that are passed related to domestic violence around the country as they get passed, which I think will be pretty cool. We're hoping to have like a map of the U.S. You can click on states and stuff. We'll look for that later this year, maybe early next year, hopefully later this year. So what bills do we track? So this is the Resource Center on Domestic Violence, Child Protection, and Custody. So that's what we're looking at basically. Generally, we're looking at the overlap of domestic violence and child issues. So bills that address the rights of domestic violence victims, we track all of those. Crimes of domestic violence, that includes things that are specifically labeled DV, and also things that are DV related, like stalking and strangulation. Those are disproportionately domestic violence crimes, so we track those too, even if the legislature doesn't call them domestic violence. We also look at bills that address custody laws when they impact domestic violence victims, like joint custody presumptions, parental alienation. We'll be talking a little later in the webinar about friendly parent provisions. And that's another common custody provision that can disproportionately impact DV. Any bills that address protection orders, even when those are not directly DV related, because those often have a disproportionate impact on DV. We'll be talking about that pretty soon with the red flag laws. And we also do child trafficking bills, specifically child trafficking bills. So when they talk about kids, we do it. When it's just general trafficking, we often don't, but we'll talk about that later. And finally, what's this presentation about? So again, this is the first time we've done a webinar for this project. And what we did for this is we kind of looked at some of the recent legislative trends over the past few years. So we're looking at a few different trends. We're looking about some red flag laws, some landlord tenant bills, some technology-related stuff. And the kind of approach here is we want to be putting, I see a question. This is great. As Amber mentioned, you can ask questions. We do track laws that talk about teen dating violence. Dating violence, domestic violence, that's close enough. So we're going to be looking at some trends we've seen over the past few years. And you can maybe start thinking about how different states are doing things and which way you feel like is best for your state. Because we kind of view this as a resource, particularly for people at coalitions, but also people on the ground, just looking at how different states are dealing with issues surrounding domestic violence. And just as kind of a big caveat, this is a pretty brief summary of what we've seen. The bills that we're going to list, these are not exhaustive of the topic areas. These are only a sample of the relevant bills that we run into. We always cite the bill. We cite the relevant statute when we can, which I think is almost all the ones in this webinar. And I just say that because sometimes these bills are passed and the bill itself won't say where it's getting codified. And in those cases, we don't spend a ton of time figuring out where in the statutory whatever the things show up. So here are the trends we'll be talking about. The first, extreme risk protection orders. I call them that because that's what a lot of states are calling it. These are commonly known as red flag laws. These are protection orders that are generally about taking away people's guns or preventing people from getting guns. This has been a trend, and I think like 15 to 17 states have these now. We're only going to highlight a few of the most recent ones, but we'll be talking a little about the differences. In the child custody arena, there's friendly parent laws. These are very common. I think most states have these at this point. We'll be talking about a few. I think there's some domestic violence exceptions that states have been passing. Victims' rights, anti-discrimination. This is a few different things. So landlord-tenant laws that affect domestic violence, generally that let DV victims terminate a lease, which is very close to my heart because I used to do a lot of landlord-tenant work at a DV place back in New York. Employment law, healthcare and insurance. Animal abuse, as it relates mostly to civil protective orders, both in terms of obtaining a protective order based on animal abuse and whether a protective order can protect the animal. We'll be talking about technology, which is a real hodgepodge of topics. But we see this coming up a lot with the more technology advances, kind of the more ways that abusers have found to use it to leverage it against their victims. So remote filing is a helpful thing for victims. Filing in court. We'll also be talking about technology-related abuse, telephone-related release and CPOs and drones. And finally, bail reform. And this bail reform is kind of a sideways topic because it's something that doesn't always impact domestic violence. But I think it's important to be thinking about because a lot of states have been talking about bail reform lately. And I think it's important when you're looking at eliminating money bail to think about the impact on domestic violence victims and make sure there's provisions in the code dealing with that. But that's my personal view, not the council's, because none of this is anybody's specific view. Protection orders. So these are also known as red flag laws, as I mentioned at the top. These are, well, first, are there any questions right now? I see we have one. Yes, I think you can. I actually think there's a way through the files now to download this PowerPoint. There should be like a little files window that you can click on. And if it's not there now, it'll certainly be there by the end. This audio is also being recorded, and there's also caching that'll go along with it. So that these resources should all be available. Extreme risk protection orders. These are red flag laws. These are aimed at preventing possession of or requiring removal or surrender of a firearm, which usually means taking away people's guns and making sure they can't get any more. These are generally focused on individuals at a high risk of harming themselves or others. And again, I call these extreme risk protection orders because that's what a lot of states are calling them. There's been a template put out that a lot of legislatures are enacting, often with just minor changes, that calls it this. So this is something to look for. When you look for these in the media, they're generally called red flag laws. That's what news articles are saying. So some aspects of these to think about are predictive or prospective language. Because one of the big differences between these and traditional protective orders is all they're alleging is that someone poses a risk. A typical CPO, you go to court and you allege the abuser has committed these acts in violation of the law, or these acts that entitle you to get a CPO. And with an extreme risk protection order, you don't need to allege a specific act. You need to allege, based on some set of facts, that somebody poses a risk, usually to themselves or to others, because they own a gun. There's some variance between the states as to who can file one of these petitions. Pretty universally, it's law enforcement. but many of them also allow like a family member or a household member to file, and that's kind of the biggest overlap with domestic violence. Many of them also allow mental health professionals to file, which is a really interesting aspect to this that we're going to talk about. The burden of proof varies a little between the states as to what the petitioner has to prove to get the guns taken away. Many of them require notice to past victims. So if there's been some kind of civil or criminal history with the respondent in one of these cases, many of the laws will require notice to a past victim or to a current alleged victim to help protect their safety. A lot of these laws are also being passed with specific requirements as to how the gun gets surrendered, if the person has a gun, with specific directions to like a sheriff's office or law enforcement, which I think is really helpful, because when you look generally at how CPOs are enforced, the studies say like it's good when they're very specific as to what people do. So an order that just says get rid of your guns is probably not as good as one that says, at 12 to 1 o'clock on a Tuesday, maybe not a Tuesday, but go to the police station, keep your gun in a lockbox, hand it to such and such officer. That helps for enforcement a lot. And also, a lot of these statutes have the opportunity to petition the court to remove the order. We're not going to be highlighting that as carefully when we talk about the state differences, but that is often an aspect of these. And it's kind of interesting because it's not something that you see so much with traditional CPOs, at least on a national basis. First one, so this is Illinois. They call it the Firearms Restraining Order Act. It can be filed by family of the respondent or by law enforcement. They have to propose specifically an immediate and present danger of causing personal injury to themselves or others with a firearm. To get an ex parte order, you need to show probable cause. And to get a 6-month order, they need clear and convincing evidence. This is actually the kind of the weirdest jump in evidentiary standards that you see. A lot of states will have a jump. A lot of states will say it's a lower burden of proof to get the ex parte than to get the durational order. But this is a jump. In this case, there's no preponderance in the middle. It's you go from probable cause, which is, as attorneys may know, is relatively low. That's like the standard for police to get a warrant and stuff, up to clear and convincing evidence, which is an elevated civil burden of proof, like somewhere between a preponderance and the criminal standard. This law also requires that notice be issued to any and all intimate partners when there's an immediate and present danger, which is good. It's the kind of thing that's designed to protect victims. This provides, there's something in there about police seizure of firearms, any identification card for like a firearms license, and concealed carry licenses, as well as prohibition of obtaining additional firearms. And the additional firearms thing is pretty universal. Most of these will say you can't get more guns too. Part of this is the court may consider, and there's a long list of things they may consider, but one of the things they may consider is whether there's been a violation of an emergency protective order under the Illinois Domestic Violence Act, which is like their civil protective orders over there. So you can see there are elements here aimed to help protect victims, both in the notice and in the reference to whether there's been a previous protection order violation. Delaware's is the Lethal Violence Protection Orders. This one is very similar, can be filed by family, including anyone who could file for a civil protective order, which is somewhat broader than family, and also law enforcement. Immediate present danger, physical injury, kind of the same. Ex parte orders here are preponderance, so it's a little higher than probable cause, like we saw in Illinois, and then they can issue up to 1 year. It's clear and convincing evidence. There is a process for surrender or seizure, depending on what's necessary for law enforcement. Massachusetts, very similar. This can be filed by family and the licensing authority of the municipality where the respondent resides. So I think that's the firearms licensing authority, rather than law enforcement directly. It's similarly still a government agency. Ex parte orders need to be reasonable cause. I did not research what specifically that means under Massachusetts law. Maybe somebody from Massachusetts would know that. Might be related to probable cause, not really sure. And up to 1 year orders they can get based on a preponderance. Massachusetts also, like many of these laws, provides a specific process for surrender of the firearms and firearms licenses. And any petition may also include whether there's been any abuse or harassment prevention order in effect against the respondent. The court's encouraged to look at, was there a previous civil protective or criminal protective order against this person when we're thinking about whether to take the guns now. And the last one is Washington, D.C., as opposed to Washington, the state. Petition may be filed by family, law enforcement, and very interestingly, mental health professionals. Not a lot of states are doing that, but a significant number are. Respondent must pose, same thing, significant danger of causing bodily injury to self or others. Ex parte orders are probable cause, like we saw in Illinois. 1 year are only a preponderance, though. They're not as high as clear and convincing, which is somewhat rare as these laws go. The court may consider the respondent's history of violence, as well as any evidence of a mental health crisis. So that is the kind of the overview of what we've seen with the extreme risk protection orders, also known as red flag laws. Krista?
Thank you, Kevin. And hello, this is Krista Delgado, and again, I'm with the Texas Council on Family Violence. Excited to be with y'all today. Just to follow up on the extreme risk protection orders conversation that Kevin just started, I'll offer some thoughts coming from our perspective here in Texas, where we've had some additional considerations as these proposals have arisen in our state, particularly because the proposals that we've seen plan to broaden and add these types of lethal violence protective orders to the Texas Family Code, where our family violence protective orders already sit. And concerns that we have about that are, one, just any opening up or highlighting of our protective order statute we take very seriously. It is a part of the law that we tend to guard, particularly because it is associated with firearm prohibitions, and anytime there's additional attention at that statute, we are concerned that some might take aim at the actual firearm prohibitions that exist for the family violence protective order respondents. The other piece is that we tend to have concerns that broadening the protective order statutes beyond family violence victims as applicants or family or household members can sometimes tend to more or less weaken the statutes and just the general public perception and the court's perception about the weight of these orders and whether or not they should be providing them. The other two considerations that we have and share with some of the broader community when we're talking about gun control is really thinking about is should our efforts and attention be on this sort of responsive reactive crisis control, or should we be looking more at how someone is even able to obtain a gun in the first place? Because relinquishment tends to be a much harder subject to tackle, particularly in states like Texas. And the last piece that we've talked with other groups about is the potential chilling effect this could have on people that really need mental health or crisis services, and that if they believe that by approaching or by getting that help that they might be targeted or that their weapons might be taken away, they might be less likely to seek out or receive the services that they need. So just some additional considerations that we've had here in our state over the last couple of years around these types of orders. I'm going to move us forward into the landlord and tenant overview. And this is very exciting because this is an area of policy and law that I've been working on at the Texas Council since I came on in 2002. We passed our first property code amendment and protection for survivors of domestic violence in the housing context in the session in 2003, and just in our last session that ended Memorial Day of 2019, we were able to successfully expand our lease termination clause. So I'm going to talk a little bit more about the general trends in lease termination laws that exist across the country. And they tend to have certain features. So one is whether or not there's a required notice period to the landlord, and also what the landlord has to provide in terms of notice and information to tenants, whether that be within the lease or spoken. The other feature, and this is what we expanded on in Texas this past legislative session, is what type of proof or evidence must be demonstrated so that a survivor can avail themselves of these protections. Again, there's also this timing question, whether it be in the length of the notice period or whether it be when the domestic violence has happened or occurred. So we'll talk through some states that have the domestic violence had to happen in the last year. Sometimes it's in the last 90 days. So sometimes that time frame is important based on the different statutes. And then the last piece that we'll talk about and that some states have been able to successfully achieve is beyond just a lease termination protection is actual anti-discrimination or protected class status for victims of domestic violence within the housing context that doesn't just provide protection from eviction based on status as a victim, but also protection from denial of access to housing based on status of a victim. So the first state that we'll talk about is Kansas. And Kansas actually did do that broad approach where they included victims of domestic violence as a protected class so that they are protected from discrimination in the housing context. So both in renting, in approaching and applying for a rental property, but also in the eviction process. One of the features that I'll note that's interesting in the Kansas statute is that the landlord still can charge a termination fee to the person that is lawfully terminating their lease. When I first heard about this, I was a little concerned and thought, you know, that might be a really large sum of money that's similar to a reletting fee or a contract breaking fee that you would see when you didn't have this ability. The way the Kansas law is structured, though, it limits this fee that the landlord may charge to at or less than 1 month's rent. And because they do not have a notice requirement, it sort of evens out with some of the other states which require, say, a 30-day or 1 month notice so that someone is still liable for rent for another month, whereas in Kansas there's not a notice requirement, but you could have a landlord charging you an additional month's rent as the termination fee. They do have a time period in terms of the Kansas law with when the domestic violence must have occurred, and there it is within the past 12 months or year. And they have different types of proof that can be offered to the landlord, and including a sworn statement by the victim themselves. So this is much more accessible than even third-party documentation that we'll discuss in other states, but that a victim's own affidavit of the violence could count as evidence in order to take advantage of this protection. And that's Kansas. We're going to talk about Nevada. So in Nevada, they already have this statute, but they have a very broad third-party documentation list. So it includes members of the mental health community and varying members of the mental health community, members of the medical field, police reports, civil protective orders, or advocate statements. So they have a pretty broad third-party documentation. They do have a truncated timeline from when the domestic violence must have occurred in order for someone to be able to take advantage of the lease termination statute. They have a 3-month or 90-day timeline. And there's also, it includes victims of harassment, sexual assault, and stalking. Some of the other features of the Nevada law that I found interesting was that it addresses access to deposit. And when our lease termination laws don't explicitly address returning of the security deposit, it is quite likely that the victim that is able to potentially lawfully terminate their lease might not actually receive that deposit back. So that was one feature of the Nevada law that I thought was really interesting. Another feature is that in addition to the lease termination provisions in Nevada, survivors can also request that they have this type of proof, and if the domestic violence has occurred in the last 90 days, that the landlord changed the locks. And this is an interesting approach to safety where someone might actually want to stay in the same residence but want additional safety features added. And then the last piece that I'll just mention about the Nevada law is it allows for the landlord to go after the party that committed the adverse action, so the perpetrator party, regardless of whether or not the perpetrator was actually a co-tenant in the apartment. So that perpetrator could be held civilly liable. And so this gives an avenue for property owners to go after damages from that perpetrator, even if the perpetrator themselves was not a tenant or occupant. So moving on to the Texas statute. So what we were able to achieve in this past session was to include additional types of documentation that a survivor of family violence is able to show so that they can lawfully terminate their lease. We initially passed a lease termination statute in 2005 in Texas, but it was very limited to survivors of domestic violence that lived with their abusers and that either had a final protective order or a protective order or temporary injunction within temporary divorce orders. So it was specific to a very, very small set of survivors. And since 2005, we've worked with our allies in the sexual assault community to expand that. So it was expanded to include victims of family violence that do not reside with their abusers, those victims, as well as victims of sexual assault or stalking or parents of child victims of sexual abuse, do have a 30-day notice period that they must provide to the landlord. So unless someone is living with the perpetrator that the landlord can then go after for the rest of the rent and liability, every other victim in Texas under our statute does have a 30-day notice period. As I mentioned previously, victims of family violence that wanted to lawfully terminate their lease had to either show a family violence protective order under the Family Code or a temporary injunction in temporary divorce orders. We expanded this in this last session to include what we call here in Texas magistrate's orders of emergency protection. These are orders that are issued upon arraignment when someone is arrested for family violence. And so they issue an emergency protective order that is criminally enforceable as part of their bond conditions. So now someone, and the good thing about including these emergency protective orders is, as you could imagine, these come through right when a perpetrator is arraigned following an arrest, whereas a family code protective order in our state is something that a victim must themselves proactively apply for and seek, and oftentimes takes 2 weeks, if not more time, to actually obtain that type of order. So the magistrate's orders are much more quickly accessed if they are issued after an arrest. The other types of documentation that survivors will now be able to offer are these types of third-party documentation. When the sexual assault and stalking victims came into the law, they were initially able to provide third-party documentation, but that was not mirrored in the family violence section of our lease termination statutes. So now we have brought it into balance so that all victims of family violence, sexual assault, or stalking may show a documentation from an advocate from a local domestic violence or rape crisis center. They may show documentation from a medical provider or documentation from a licensed mental health provider. So we're very hopeful that this is going to continue to help more and more survivors in Texas. We've seen our lease termination statute be one of the most utilized statutes that we have here in the state because it tangibly helps survivors avoid a lot of additional cost and allows them to do what they need to do for their safety without amassing a bunch of debt and poor rental history. The other part of our Texas property codes that protect survivors and now broadly protect all victims of crime are more around nuisance ordinances. So I mentioned that we passed our first property code protection in Texas in 2003, and this was essentially a right for a victim of family violence to call 911 or emergency assistance without being penalized or evicted by their landlords. And so this section of our property code was expanded 2 sessions ago, where now it applies to any crime victim that they may not be penalized, prohibited, or evicted because they sought intervention or emergency assistance in response to a crime. And so this is in response to a lot of those nuisance ordinances that you've probably heard about across the country. We've seen provisions in leases that say if the police come out to your property, you'll be penalized or you could potentially be evicted. And this is really to address and protect victims of crime so that they can access the public safety services and emergency services that they need without fear of losing their housing. All right, and I'll go and, because I see that they have some questions here, let me see, in the chat box that's still pertaining to landlord-tenant. There was a question about, aren't victims of DV considered a protected class in the Fair Housing Act? Federally, no. So in the Federal Fair Housing Act, victims of domestic violence are not one of the explicitly protected classes. We have seen, and particularly pre-Violence Against Women Act or VAWA housing title protections, we did see lawyers doing some really creative work in terms of litigating on disparate impact claims, and so saying that because women are disproportionately the victims of domestic violence, by evicting or denying housing to someone based on their status as a victim, that disparately impacts women, which women or gender is a protected class within the Fair Housing Act. Now, each state has their own Fair Housing Act and laws, and so like in Kansas, victims of domestic violence are seen as more or less a protected class with others, but not every state sees victims in that way.
And I'll just add in there really quick. There are a couple federal protections, because I used to litigate around some of this. So the Violence Against Women Act does provide some housing-related protections for people in public housing and people getting Section 8, as well as some other federal subsidies. There's this whole constellation of federal housing subsidies, and under VAWA, people who are getting those do get certain protections related to domestic violence. But it's only for that. It's not generally in the Fair Housing Act.
Great. And there's a great consortium, the Safe Housing Consortium, that folks from the National Alliance for Safe Housing and from the National Network to End Domestic Violence are a part of. So if you have any questions or technical assistance questions related to particularly the federal protections that exist under the Violence Against Women Act, or more broadly under some of the newer federal funding streams that apply to victims, there's lots of great technical assistance resources out there, and I'm more than happy to connect you with those. All right, I'm going to move on into the employment section, and this is exciting to be able to talk about what some of the states were able to achieve recently in their legislative sessions over the past year or so. Texas has had access to unemployment compensation for survivors of family violence, sexual assault, and stalking for several years if they can show certain types of proof and are otherwise eligible for unemployment compensation in our state. But we do not have any job-protected leave in the state of Texas. And so it's been really heartening to see, particularly in our last legislative session here in Texas, there was a good amount of legislation that was filed, none that actually passed, but that did look at some of these themes that we've seen successfully passed in other states around paid sick or safe days, around codifying job-protected leave, whether or not it was paid or unpaid, looking at anti-discrimination in the employment context for victims of domestic violence, and really looking at sexual harassment in the workplace more closely. And so in terms of the examples that we'll talk about today, some of the amendments we're focusing again on anti-discrimination in employment practice based on someone's status as a domestic violence victim. Sometimes it's based on whether or not that they have a protective order in place. And some of the statutes are very explicit in terms of that protection, that anti-discrimination exists and protects someone even in light of their perpetrator coming to the workplace and harassing them, because we know that that's such a frequent occurrence for victims of domestic violence. And so often they do lose their employment, not based, the employer might say it's not because you're a victim, but it's because this person is providing a nuisance and we're not able to feel safe or productive in the workplace because this other person is coming and harassing everyone. Another theme that we've seen is around job-protected leave. So that can be sometimes in the form of paid sick and safe that are broad, but that you can use those paid sick days for quote-unquote safe days to address anything that comes up related to an assault or an incident of domestic violence. And sometimes it's explicit to just job-protected leave for a finite amount of time based on someone's status as a victim of domestic violence and need to take time off to address those issues. And the last theme that we've seen in states is where the employers are required to make reasonable accommodations around employee safety and so that they can take care of themselves in light of the domestic violence that's occurred. So in terms of the different states and what they've done, we've seen Washington, D.C. Has actually included domestic violence victims into their protected class of folks. So that not only means that they have protected status or anti-discrimination protections, but that within that anti-discrimination status includes the fact that they cannot be discriminated against if they need to take time off to address issues relating to the violence. And so they don't have an explicit job protected leave, but it's protected within that anti-discrimination section. They also have reasonable accommodations that the employers must make. And this applies not only to victims of domestic violence, but also sexual assault and stalking offenses. One of the things I thought was really interesting when reviewing the bill in the District of Columbia is that they already have protections around discrimination from your credit report. And so I'm excited to go back and look at their laws around that because it's broad, not specific to victims of domestic violence, but we know oftentimes victims of domestic violence have damaged credit based on the abuse that does create a barrier to employment. So I just thought I'd point that out as something that DC has already done. In New Jersey, they broadly require employers to offer sick and safe days, and so that includes the ability for folks to take advantage of this paid time off to address issues relating to the domestic violence. So it's under that larger umbrella of folks being offered, if they are employees for a certain tenure and they work a certain number of hours, they are entitled to some type of paid sick and safe leave. And then in Nevada, they have reasonable accommodations, and they also have anti-discrimination. The leave in Nevada is what I see as incredibly generous. They offer 160 hours of leave within a year for domestic violence victims, which is 20 full days. And this can be taken cumulatively or intermittently throughout the 12 months. And their statute also offers access to unemployment compensation for victims. So it is one of the more comprehensive statutes around employment protections that I have seen. We'll pause here and see if anyone has any questions related to the employment laws or any comments that you'd like to share before we'll move on into healthcare and insurance.
I'll just address one thing really briefly. As Hannah mentioned in the chat box, New York had a really exciting landlord-tenant bill this past summer, which made a lot of really great reforms, a few related to nuisance and stuff. But it was really exciting. Okay, so if there's no questions, we'll move on to the next section, which is a brief one on healthcare and health insurance. The protections here are, hold on, oh, here, sorry, the thing was lagging for a second. So healthcare and health insurance, we just have one slide on this. And a lot of this, as Krista and I were going over this, I realized this is a lot of this is just mirroring what the Affordable Care Act requires. And some of this is a not very interesting implementation of that. So there are certain things that the federal law requires that states do in their health care bills, like covering DV, like saying that DV is not a pre-existing condition. And that's what a couple of these are doing. So the DC code, for instance, requires coverage for some DV-related services, like screening, counseling, other health-related treatment for victims. Virginia code prevents insurers from making domestic violence victims ineligible for coverage. So if they want to treat domestic violence like a pre-existing condition and try to deny coverage on that basis, they can. Maybe the most interesting one here is New Hampshire's. This provides a waiver for victims of domestic violence from any work requirements for publicly funded health insurance. Now, not all states have that. Back when I was in New York, I did a decent amount of public benefits work, and I believe, at least as of a couple years ago, Medicaid in New York did not have a work requirement, unlike public assistance and in some circumstances food stamps. So this looks like an implementation of the family violence option, which is an aspect of the welfare reform bill from the 90s that allows states to implement a waiver for domestic violence victims from any programmatic requirements for any kinds of public benefits. And this is most commonly used in the food stamps and the welfare context. But it's pretty interesting that New Hampshire is also using it here for their work requirement related to health insurance. But Krista, do you have some comments about Texas' version?
Sure, yes, and I'll just add that in Texas, like you said, we've taken up the family violence option for cash assistance and for adult Medicaid. And so if an adult is receiving Medicaid in the state of Texas, one, it's almost impossible for an adult to receive Medicaid in Texas unless they are a parent of dependent children that's also TANF eligible. And so one of the requirements for participation in adult Medicaid is that that parent apply for or cooperate with enforcement of child support. So for that particular requirement, we have included the family option so that those Medicaid applicants can waive the child support requirement if it is not safe for them to pursue child support. The other thing that we've done since the Affordable Care Act has been passed, and this is a state policy within our Health and Human Services Commission that administers the Medicaid and Children's Health Insurance programs, is that for applicants for Children's Medicaid or Children's Health Insurance Programs, or CHIP, they can apply for what's called the Family Violence Exemption. And this means that because now all of our health care coverage, even Medicaid and CHIP, which is federally funded and partially state funded in the CHIP sense, it's sort of something that you might apply for in your regular benefits granting office. Those programs are now under the Affordable Care Act. And so the way in which they're determining household and income, et cetera, is going the same way that exchange would determine that, and that's by your tax family. And so we know that oftentimes survivors of domestic violence are estranged from their partners or spouses, but it's highly possible that that partner or spouse intends to either file jointly so that they can receive the earned income tax credit, or claim the children as dependents on a tax return, which would mean that on applications for any type of health care coverage, someone would have to disclose that that person was a member of their tax family, and then that person, again, potentially the abuser, would be considered a part of the case, and their income would also be calculated into the eligibility determination. And so here in Texas, we have what's called the Family Violence Exemption, and if it is not safe for an applicant for Medicaid or CHIP on behalf of their children to reveal the name of that other parent and to include them on the case and as a member of their household or case, then they can actually get this exemption so they do not have to include them. Then that person is excluded from their case, and which is most notably, their income is excluded from the eligibility determination. So it helps to make kids more likely to qualify for Medicaid and CHIP programs than if you would have had to include the income of the other parent as well.
Well, thank you, Krista. Do we have any questions so far? Healthcare, anything else? All right, well, moving on to bail reform. Here we go. So this is a topic that, as I said before, is kind of sideways related to domestic violence. And often the most interesting part of a bail reform statute is that it doesn't talk about domestic violence. So if people aren't really familiar with this, there's been kind of a trend across the country to start thinking about what do we do about bail. A lot of people have said, and a lot of researchers have said that money bail kind of disproportionately impacts the poor and doesn't do a whole lot to actually protect people. Because really what you're doing is you're locking up people who don't have money. And the amount of money you have is not necessarily directly related to what kind of danger you pose to the public or to a specific victim. So a lot of states have been trying to replace bail or reform it and replace it with like an assessment, conditional release, or a detention in serious cases. So thinking about how do we figure out what kind of a danger someone poses, and then what kind of conditions do we use, or up to the point of detaining them, if that's what we need to do. California has a bill on this. New Jersey has a bill. New Jersey's courts actually are implementing something. It's really interesting what they're doing. But something that I want people to be thinking about is when you're looking at bail reform, how do you make sure that DV victims are still protected? Domestic violence is the kind of crime where the perpetrator is pretty likely in a lot of scenarios to go back and commit similar crimes against the same victim. It's a very different kind of consideration than you get in like, a standard robbery or whatever else. So it's the kind of thing that people should probably be thinking about. And the kind of things states are doing include providing hearings for all domestic violence offenses prior to release, imposing certain specific alternative bail conditions for domestic violence offenses that are designed to protect crime victims, and looking at the types of assessment tools. So a lot of what states are doing here is they're having these often like computerized assessments where they're looking at like somebody's history and whatever other factors that they have about the person and figuring out, is this person likely to commit another crime if they get released? Or if we do release them, what kind of conditions can we use to try to make sure that they don't commit another offense? So the first state we're looking at is Utah. In Utah, bail is usually granted as a matter of right. This bill added a domestic violence exception when the court finds both substantial evidence to support the charge, criminal charge against the defendant, and clear and convincing evidence that the defendant would constitute a substantial danger to the victim if released. And I'll just note, this is a relatively high standard. And clear and convincing evidence, it's not beyond a reasonable doubt, but as I mentioned earlier for some bills, it's an elevated civil standard. But it's a pretty significant finding that this bill is requiring. This bill also allows for specific release conditions when the judge finds that it will help protect the victim, including no contact, no threats or harassment, and no entering the victim's residence. And I think that's pretty standard with what we see among criminal protective orders. But good that they're considering it in the pretrial context. California has greatly revamped its bail system. So we have a question about Utah. How are those release conditions enforced? The answer is I have no idea. All I really know is this statute. I would imagine that this is enforced like a court order would be, so I suppose if someone found out that the order was being violated, like the victim, they could probably call the police. That's how we would have done it in New York. I don't think this bill was talking about like electronic monitoring, any of the fancy technological stuff that you see in some of these bail bills. So other than that, I don't know. California had a big revamp of its bail system for people who've been following this topic. I think there might be a proposition that's threatening to change it. I don't really follow California politics that closely. But the way the statute worked, the way the bill prescribes things is they're going to use pretrial assessment services to evaluate the risk of release with a presumption in favor of release, but based on the evaluation that they get. And there's a specific exception in the bill for those who have allegedly violated an order of protection. So for those kind of crimes, they're saying maybe we shouldn't have a presumption in favor of release if they've already shown that maybe they won't be following a court order. Delaware generally requires the court to release defendants with minimal conditions unless they're necessary to protect the victim or others, or to ensure that the defendant appears. So that's the basic standard the court looks at when it's deciding what conditions to impose. And specifically when it's a domestic violence offense, and the statute kind of enumerates what it considers a domestic violence offense, the court must consider the results of an assessment tool designed to predict the likelihood of future violence against the alleged victim. And one thing I want to highlight here that Delaware is doing is they're doing a specific tool for domestic violence. These assessment tools are everywhere. Like a lot of states have started using them. And what Delaware has done is recognize that there are you might need a different kind of assessment for your standard crime and for your domestic violence offenses. And so that's kind of what they're implementing. I believe the last one we're looking at is Georgia. There's a bail reform bill that keeps pre-existing family violence protections mostly intact. And that's something to consider. A lot of states are looking at bail and they're saying, okay, let's just repeal our whole former bail code and pass something new and cool with these assessment tools, which is great. But it's like when you're thinking about domestic violence, family violence, as Georgia calls it, it's important to think about the protections that were already in place. and thinking maybe if we had something that was kind of working, at least for these kind of crimes, maybe keep it in place. That's what Georgia did. Georgia also has mandatory bail conditions for domestic violence offenses, such as no contact, no physical abuse or threatening, and in certain cases, domestic violence or other appropriate counseling. I know there have been some constitutional concerns and other attacks on that kind of statute, but Georgia has this in the bill. I don't know what assessment tool they're using in response to this question. I have resources for this, but not prepared for this webinar. If you contact us separately, I can hook you up with some of that. But there are a few different assessment tools going around. Krista, would you like to address it?
Sure, and I just copied and pasted information about the pretrial risk assessment information system for Texas, which is what has come down from the state and the Office of Court Administration as sort of the risk assessment to use. It's called Praise Text. It's a web-based application, and so as you mentioned, Kevin, there are some issues with algorithms and with any of these that aren't specifically made for crimes of domestic violence, and none of the assessment tools that I have heard about being used, at least in Texas, have incorporated feedback or considerations from the domestic violence advocacy community. But you can look online and find it. It's from the public safety assessment, which is where we draw ours from. But there's a constellation of different tools that jurisdictions are utilizing. Again, I think where the domestic violence community needs to weigh in more is how those actually fit when we're thinking about the safety of victims.
Thank you, Krista. This is kind of a wide-ranging discussion, and we're not going into a lot of the details of how assessments work. We're just kind of looking at what some states have done. I think it's important to think about how these assessments are going to impact domestic violence victims, how changing existing protections might affect cases as they come up. Any more questions about bail before we move on? All right, so next we're going to talk about friendly parent provisions. This is kind of what we call these provisions, but generally speaking, sorry, let me move the PowerPoint. Generally speaking, we're talking about best interest factors. So in child custody, most states, in fact, I think every state is going to look at what's the best interest of the child. And most states have a list of factors for the courts to look at when they're making that determination. One very common best interest factor is one that rewards a parent who promotes the children's relationship with the other parent. Basically, it'll say the court should favor custody with the parent who's most likely to encourage a relationship with the other. About 40 states have these, as of some research that we did earlier this year. Only 18 states have an exception for domestic violence, meaning telling the court if there's been DV, don't look at this factor. And that's what most of the bills we're going to be looking at are talking about. The reason we're highlighting these is they can be very problematic in domestic violence cases. There's been a lot of research on this. And the research basically shows that these provisions weigh pretty heavily against domestic violence victims. Like if this is in the statute, even if the statute also has domestic violence best interest factor, which almost every state has, these factors, or these friendly parent provisions, tend to greatly outweigh the domestic violence factor when you look at how courts are making decisions. So Louisiana substantially modified its custody provisions in a pretty big DV bill in 2018. They added the specific exception that's quoted on the screen when there's objectively substantial evidence of specific abuse, reckless or illegal conduct, has caused one party to have reasonable concerns for the child's safety or well-being while in the care of the other party. And this is a specific exception to the friendly parent provision. So the court's basically being told, don't look at this provision when you see this kind of evidence. Now, this is a fairly limited exception, I would think. Objectively substantial evidence, not just any evidence, and specific abuse, reckless or illegal conduct. Because what the research has shown is that even when you have a domestic violence exception in the friendly parent provisions, usually courts are going to lean towards just using the friendly parent provisions. Even when these things aren't in the statutes, you'll see courts talking about this kind of thing. But yeah, so this is what Louisiana did in 2018. Here we have Utah again, which we just talked about for the bail. They also added an exception to the friendly parent provision when the court determines that the parent is acting to protect the child from domestic violence, neglect, or abuse. Then the court can take those protective actions into consideration. And this is similar to Louisiana. The way the statute's thinking about it is like, well, maybe this kind of behavior, what people would call alienating behavior, you'll see references to parental alienation in a lot of these statutes. Maybe this behavior is normal when the other party has committed acts of domestic violence, and when the party is acting to protect their child from that kind of thing. The same bill also added domestic violence as a best interest factor, which is great, and also added DV as an exception to the rebuttable joint custody presumption, which gives me a quick segue into that. And we didn't see this in this set of legislative updates, so it's not in the slides right now. But joint custody presumptions are also very problematic. I think Krista's going to talk a little about that.
Yeah, so in Texas, we don't per se have a friendly parent provision, but we do have a presumption of joint managing conservatorship, which is not exactly 50-50 or equal parenting, as I'm sure many of you have heard about, but it's very close, and it does mean that both parents share in the decision-making regarding the child, as well as in who gets to dictate the primary residence, so that's a shared decision. And what we did see this last session in Texas was just a whole slew of bills that would amend our custody statutes in dramatically different ways. And so on the side of ones that we feel had intent that would have been harmful to victims of domestic violence, we saw a bill that would have raised the evidentiary standard in custody determinations when you're looking at a history of domestic violence or child abuse, raising that someone would have to show that the evidentiary standard to show domestic violence or child abuse would be as high as that to terminate parental rights. And so that would have obviously been disastrous for survivor parents and their children. Did not pass. We also saw several bills that really looked at asserting the fundamental rights of parents and the protection of parental rights, and putting these in the best interest of the child sections. So really, instead of thinking about child safety in best interest of the child and well-being, really inserting parents' rights and both parents' rights in there. And so we successfully were able to derail those initiatives, but we also saw a good number of proposals that had really good intent, but came from groups that hadn't had a lot of experience doing family law work in Texas, and so they didn't really align with the way our codes were written. And what we found this last session was we really are building coalition with not only the family law attorneys in our state, both in the private sector, as well as our legal aid and pro bono attorneys that practice family law with survivors, but also with the broader child advocacy and child welfare community. And we found that when we have folks that are consistently talking about child safety and child well-being as their main focus, when we can bring them into the conversation and to support our statements around the harm that domestic violence prevents to children and the way in which custody is incredibly important to child safety and well-being, we gain a great deal more traction. And so that is just one strategy that I would put out there, particularly if you're dealing with 50-50 parenting bills, equal parenting, or things that look like initiatives that are going to really further the conversation around parental alienation, which almost undoubtedly harms survivor parents and their children, is to really start to educate and ally with your child welfare and your child advocates, because then our coalition on these issues is much stronger, and it makes a lot more sense because I think the general public hears things like protection of parental rights, and that sounds good. And in a lot of cases, and in many families, that might be a good thing. But there's not a nuance to that conversation as to why that could be dangerous in cases where there's been a history of domestic violence or child abuse. And so I think that that's there's some important allies to bring in to those conversations around custody that historically, at least here, we hadn't been routinely talking with throughout session.
Yeah, it's really important to consider the broader context of these and what the impact is going to be on domestic violence victims. That's why we track things like the friendly parent provisions, because often, like in most states, they don't even talk about domestic violence. But when you look at the research on the ground, they're having a pretty big negative impact on them. So that's why we look at this kind of thing. It's an important thing to consider. Do we have any questions about friendly parent or alienation? Okay, so our next topic is animal abuse. Hold on. There we go. Animal abuse. This is linking animal cruelty or animal abuse to domestic violence. And we're kind of looking at two major things here. One of them is whether you can get a civil protective order based on abuse to an animal. And the second is whether the protective order that you get can protect pets or provides provisions allowing a survivor, say, to leave with their pets or something. We're considering both civil protection orders and criminal statutes. And the main things to look for are pet-related relief and protection orders and amendments to existing criminal definitions or creation of new offenses, including civil offenses for the purpose of CPOs. And the reason we look at animal abuse is it's something that can have a big impact on survivors. When I represented people back in New York, we would see this a lot. People would make huge decisions based on their pets. Like even the decision of, do I leave my abuser, would be like, well, what's going to happen to my pets if I go? And we would also see pretty frequently threats to an animal that a survivor was close with as a form of domestic abuse, saying, if you leave, I'm going to kill the dog, or something like that. So it's something that's a big concern, especially when we look at like domestic violence shelters, because a lot of shelters won't take dogs, which can be a huge problem when the abuser is trying to flee. So anyway, Wyoming had a recent interesting bill, prohibits the respondent from having contact with any household pet in the petitioner's custody. So it's like a no contact order as part of the CPO, but also no contact for the pet. Which you can see that being important in a few cases. Like if, say there's going to be like a pet sitter or the pet dog's going to like a doggy daycare or something. That's a scenario where a no contact order for just the petitioner wouldn't necessarily protect the pet, but that's what this does. The statute also allows the order to grant sole possession of a household pet of any party or a child to the petitioner during the period of the order, for the purpose of protecting the household pet. So basically, it's not the survivor can flee the home, they can get a protective order, and they can get specific possession of the pet. Or if they're kicking the abuser out, this makes sure that they get to keep the pet. which is very important to a lot of survivors. Utah also expanded its definition of domestic violence for criminal purposes to include aggravated cruelty to an animal with the intent to harass or threaten the cohabitant. And that last language is something that we see pretty commonly. Again, this is only very recent bills, but when I did a broader statutory review, a lot of animal abuse bills will, when they're looking at the domestic violence context, they'll look at, was it with the intent to harass or threaten the cohabitant? And I think states could go one way or the other on that. Because on the one hand, that's kind of an elevated standard when they're going to have to show it. But, I mean, when you're talking about domestic violence and coercive control and how all those dynamics work, it makes sense, in some sense, to incorporate that into the animal cruelty. So I don't know, that's what Utah does. Indiana also has some animal-related protections. So its definition of criminal animal abuse includes domestic violence animal cruelty. I don't know specifically how that works, but that's the phrase that they put into their bill in 2019. They also include animal abuse as part of the definition of domestic or family violence. And that definition is to knowingly or intentionally beat, torment, injure, or otherwise harm an animal, including destruction of an animal by means other than humane euthanasia. And you'll notice that this definition does not have a direct reference, like Utah does, with the intent behind it. So potentially we're looking at a statute that can say, if someone's abusing a family pet, even without the specific intent to try to control or otherwise abuse a family member, that alone could be domestic violence. And there are a few states that do it this way, which I think is a really interesting approach. That is all we have in animal abuse. Do we have any questions on that? All right. Well, moving on, we're going to be talking about technology. This is the last area that we'll be going into. Well, I'm sorry, one sec. Krista, do you have something about the animal abuse to mention?
I will just mention in Texas we do include pets and protective orders in that explicitly pets can be protected or the custody of the pets can be provided for to the protective order applicant. We did have to work last session because there was an effort to expand the definition of family violence to include animal abuse, which, because the definition of family violence as it's codified, even though it is in the family code, is what is the threshold and what is used and referenced both for protective order eligibility as well as in our criminal codes. We really push back against that because that, again, might have weakened the ability to actually, for people to see that family violence in terms of the severity, even though animal abuse and destruction of pets and property oftentimes is something that we see and is articulated by survivors as they're either making police reports or in their protective order applications.
Yeah, so I think something to consider, just think about how animal abuse intersects with domestic violence, because it does a lot. Both as an indicator of when someone is committing abuse or as the abuse itself, but also as something that's important to survivors who want to be with their pets when they're leaving the abuse. So next, as you can see, Amber's posting a link to our website. The National Council has a new publication on animal abuse and domestic violence, part of what I was researching for this a few months ago. So feel free to look up that for more information. So technology. As I mentioned earlier, this is kind of a catch-all category. There are different ways that states are taking technology into account as a way to, when they're looking at how abusers are committing violence in the modern era, and when they're looking at how they can help survivors using technology. I kind of referenced this earlier with the bail bills. There are states that are looking at things like electronic monitoring for defendants who are being released pre-trial. We didn't talk about that a lot because I didn't see that in the statutes that we were highlighting here. But that's something else to consider that we're not going to talk about right now. So we're looking at misuse of technology by abusers and the technology needs of the victim. So things to look for include the ability to file for a protective order remotely, something that you can do in New York City, where I was practicing. Additions to protective order relief regarding telephones. Usually this means like transferring a phone or an account to a certain person, usually a protected person in the order. Expansion of definitions to include misuse of technology when it wouldn't otherwise be included in the DV definition. And also responses to new technologies such as unmanned aircraft or drones. So Kentucky just authorized court-developed protocols for electronic filing orders of petitions, specifically at regional rape crisis centers and DV shelters. So a little more limited than what New York had. Because New York advocates could also do it from our offices or from family justice centers. But really interesting. And you can see they're thinking about this the right way. Because a lot of the time, when a victim is just fled to like a domestic violence shelter, it's going to be tough for them sometimes to get all their paperwork in order, get down to the courthouse, spend however long you got to spend there to get an order. Electronic filing helps their safety. It means they can stay at the shelter and not have to run to the courthouse, where their abuser might even expect them to be. And it lets them get the benefit of the expertise of the workers at the DV shelters and at the rape crisis centers, who presumably are going to be trained in this kind of thing. Montana has changed its definition of stalking to include a specific reference to the use of electronic devices. This is something that we've seen, like a lot of states do actually. I think Montana is the only one mentioned here. And this is the kind of conduct that you could say, well, use of electronic devices to cause a reasonable person to fear for their safety or whatever, that's probably included in that definition, even if the statute didn't say the word electronic devices. But it's good that it does, I think. Because this means, judges and advocates and everybody, or even pro se victims, are going to be put on notice that this is the sort of thing they should be thinking about. Like, don't just think about what your abuser said. Think about like text messages or IMs or whatever kind of electronic communication they use. That could all be a violation, or that could all constitute stalking if it's causing them fear. Hannah has a comment about Rochester. I didn't know that they did it in Rochester too, but that's really great. And hospital advocates are another way to help people who are fleeing a dangerous situation file for a protection order in a safe space, and with access to expertise that they're probably not going to have, that the pro se victim is probably not going to have on hand. Several states have passed bills about phones. These bills all look very similar. And I think that at a conference somebody was saying it's actually the phone companies that like these bills and they're kind of pushing them. The way these bills usually work is they allow a court to order the telephone company to transfer an account to the petitioner in a protective order, or to the protected person. I didn't go into a lot of detail here because it's a pretty specific kind of relief. But one of the most interesting parts of it is we're looking at an order to a third party. Protective orders usually, you go to court, you file for the order, and you get some relief that's designed to protect the victim, and specifically that relief is as against the respondent, who's a party to the case. Even if it's an ex parte order, they're still named as a respondent. These are orders against third parties. These telephone providers are not parties to an order protection proceeding. But these statutes allow the court to order them pursuant to the petition in a civil protective order case to change the telephone account. And this is pretty cool. It kind of ties into what we were saying about like what Montana did, where abusers can use technology to try to control their victim. Sometimes you'll have, or often you'll have a victim who's economically dependent on their abuser. They might rely on them on like their phone account. The abuser might pay the phone bill, and so their only phone which is really their only immediate way to contact people or to contact the police if there's an order of protection violation, is controlled by the abuser, which could give the abuser access to text messages, access to phone calls, whatever other confidential information, which would be a huge problem. So I think these are basically good bills and really interesting. There's only 3 here, so we've got Tennessee, Virginia, and Colorado, but quite a few states have passed these. They're becoming a major trend. Finally, we're going to talk about drones. So drones are also unmanned aircraft. Usually, states are looking at how can a drone be used to violate a protective order. And I feel like every now and then you read stories about this in the news, like somebody used a drone to take pictures of someone in their backyard or like through their window when the person wouldn't have expected someone to be able to do that. In many cases, it's questionable whether existing law would cover the type of drone usage that we're talking about. And so actually a bunch of states have started passing legislation to try to address this. So New Jersey, for instance, says it's a violation of a restraining order to knowingly fly a drone within a certain distance of a person if that distance is a violation of the order. And this is a scenario where they really are expanding something. If an order says, like, you can't go within 100 feet of the petitioner, that wouldn't necessarily cover using a machine to go within 100 feet of them, like a drone. So this is a possibly significant expansion, saying that now if you fly a drone within 100 feet of them, and the order said you couldn't go within 100 feet, that's going to be a violation. Virginia also had a bill. This says that this is basically adding additional relief to the protective order. So it's unlawful for them to use the drone to follow, contact, or capture images of a protected party. Specifically, they can't knowingly come within 50 feet of their dwelling with the drone to coerce, intimidate, or harass. So that would be like using the drone to buzz them outside their home or flying outside their windows. They also can't follow, contact, or take pictures of anyone without their permission if the perpetrator is a registered criminal. And there's details to that in the statute that I didn't want to go into here because it's complicated. But generally, you can't use drones to follow people. So it's kind of like a stalking statute, separate from the protective order relief, which also says you can't use the drone against the petitioner. Finally, we have West Virginia. This says that it is unlawful to use a drone to violate a restraining order. And unlike some of the other statutes like New Jersey, where they're very specific about what you can't do with the drone, also Virginia, West Virginia doesn't say. And so it's a little unclear whether this is an expansion of the protective order language that's already in the statute, because it's unlawful to violate a restraining order by any particular means, you would think. So like it's a little unclear from this whether if you came within a prohibited distance of someone using a drone, but not your own body, whether that would violate the order. But the bill also provided some independent protections on things that it's unlawful to do with a drone. You can't take pictures and stuff to invade someone's privacy. You can't stalk, can't harass people. And the stalking and harassment may be debatable whether that's an expansion, but taking pictures, that's a significant one. And that's kind of what you hear about people doing with drones. Like people will hear a little buzzing noise and look up in the air, and there's like a drone with a camera on it. And you don't know who has that drone, you don't know what they're doing with it. So if someone's using pictures to like take pictures, using the drone to take pictures like inside somebody's house or maybe in their backyard, that's now an offense in West Virginia. So that is the end of our slides. Kristen, do you want to talk about technology?
Definitely not my area, but we see more of the technology-related bills and statutes when we're looking at stalking, cyber stalking, and cyberbullying. One of the things I was just mentioning to Kevin recently is that Separate from the family violence protective orders, we do have sexual assault, stalking, and harassment protective orders in our criminal codes. And I have heard that for the harassment protective orders, the applications and the evidence that is shared tends to be exclusively tech-related, either text messages, voicemails, social media posts, etc. So that definitely is a feature, but not one that I center on.
Yeah, this is a growing field in terms of thinking about technology and abuse. And I know we have some other projects around cyber stalking, some other trainings that some of my colleagues here are working on to specifically address how courts and victims and advocates can think about technology and how it impacts people. So do we have any questions about that? I feel like if we don't now, within the next couple of years, people will develop some as abusers find new ways to use it. And we were at a thing a few months ago, and someone was talking about how an abuser could, if people have those new temperature control things at their house, an abuser could remotely log in and use it to control the temperature in a victim's house, maybe open and close their garage door. It's kind of general harassing behavior that new technology makes available to them that they wouldn't otherwise have. So if we don't have any questions, thank you all for coming. Under the Files tab in the Adobe Connect software, you can download a copy of this webinar as well as our most recent legislative updates. Looking forward, you can expect for definitely a few sets of updates this year, and hopefully late this year or early next, we'll have a website up and running where we can find live just a list of new bills related to domestic violence that states are passing, which we think will be a cool resource. Krista, do you have any closing thoughts?
No, but thank you so much for the opportunity, NCJFCJ, to be a part of this webinar. And please, folks that have been participating, please feel free to reach out to me with any questions about some of the Texas-specific statutes that I mentioned or other related things. And it would be really good to hear from what's going on in your states as well.
In response to Jackie's question, if you want to print those updates, you're free to. Those are mostly not covered in this. We are mostly talking about more recent bills, although I think we had a few from 2016. That resource is also available on our website, which is the RCDV CPC website, the Resource Center on Domestic Violence, Child Protection, and Custody. There's a large list of resources there. So not just the news updates, but also just some general things that we hope are helpful for advocates and for survivors. Thank you, everybody. I hope you all got something out of the webinar, and we look forward to talking to you next time.
Thank you.